Welcome to another episode of the 39A podcast. I'm Srivastava, a law graduate from NSIU Bangalore, and I'm currently practicing at New Delhi. In today's episode, we have with us Mr. Arshdeep Singh Khurana. Mr. Khurana has an extensive legal practice at the courts of New Delhi and Punjab and Haryana. His practice primarily relates to white-collar offences with a fair bit of commercial law, arbitration and civil law, and I have the good fortune to be working under him at his chambers. Recently, Mr. Khurana represented a number of petitioners in a batch of over 200 petitions filed before the Honourable High Court of India by various individuals, challenging the constitutional validity of various provisions of the PMLA. The underlying ground of challenge was the draconian nature of the statute and the unbridled powers given to its officers under the PMLA, which are violative of various constitutional principles and fundamental rights. On 27th July, a three-judge bench of the Honourable Supreme Court rendered its verdict in Vijay Madanlal Chaudhary versus Union of India, upholding almost all the provisions of PMLA. And this judgment has been the talk of town across all legal spheres in the country since. I welcome Mr. Arshdeep Singh Khurana to this podcast today, and thank you for joining us, sir.
Thank you, Harsh.
Now, sir, we've seen various articles and discussions critiquing the judgment in Vijay Madanlal Chaudhary. Regardless of what disagreements we might have with the judgment, it is what it is for the time being at least. And as a defense lawyer, one would have to represent their client within the realm of this judgment. So in this podcast, we were hoping to take a different approach and look at the judgment from the lens of a defense lawyer and see how can one best represent their client given the circumstances and law. So, sir, beginning with the definition of money laundering first. The judgment has expanded the definition of money laundering to include even possession of any alleged proceed of crime as amounting to money laundering. So, is there any protection to a bona fide recipient of alleged proceeds of crime under the judgment?
So, Harsh, to answer that question, I'll have to first explain you really what is a proceeds of crime and what is a schedule offence and what is the structure of the act, if I can take a minute from that. So the entire act is structured on what is called a schedule offence, or what we also call a predicate offence. And it is this offence from which the proceeds of crime are generated, which are then laundered and then which gives right to a cause of action to the offence of money laundering. So a schedule offence, there is a schedule under the act which has a number of offences. Initially, of course, it started with serious offences like terrorism and narcotics. And then the schedule was expanded over the years. And today you have a number of offences under the IPC also, which are schedule offences. To give you an example, say the offence of cheating is now a schedule offence. So X cheats Y and generates rupees 100 as the crime money. That becomes what is called the proceeds of crime. It's defined as any property which is derived directly or indirectly from any criminal activity related to a schedule offence. It is what you do with this proceeds of crime which then becomes the offence of money laundering. Now, the Act itself defines what is money laundering under Section 3. And it's any use, possession, layering, projecting, claiming the proceeds of crime in any manner now becomes an offence under Section 3. So as far as the bona fide recipient of the proceeds of crime is concerned, the section itself has some inbuilt safeguards. And the most important safeguard is that you have to, when you receive it, if you knowingly receive this proceeds of crime and knowingly that this is proceeds of crime that is generated from a schedule offense, then you may be guilty. If you are a bona fide recipient without having knowledge that what you're receiving is actually proceeds of crime, then you are not guilty under Section 3. The judgment itself has not gone too much into this aspect, though it has expanded the definition of what is proceeds of crime. But as far as a bona fide recipient of proceeds of crime is concerned, the safeguards are still there in Section 3 and they have not been diluted in any manner.
Okay, sir. So basically, intention is still a factor which is considered while deciding whether someone is guilty of the offence of money laundering.
Correct. Intention, knowledge, mens rea, These all of so for give you a simple example, as a lawyer, if we receive fees from our clients, I don't know today whether that's proceeds of crime or not. So I am today, I do not have that knowledge, and therefore I am a bona fide recipient of the fees. And I today a lawyer can't be made guilty of or charged with the offense of money laundering.
I think, sir, a lot of our listeners would be very happy with that answer. That at least lawyers are not considered within the ambit. Sir, so moving on to the next question. The Honorable Supreme Court has held that ED is not bound to provide the what is called the Enforcement Case Information Report, or the ECIR, to the accused persons. Now, sir, how is that going to affect the rights of the accused persons?
I think we've been arguing this for a very long time, and we also argued this in the Supreme Court, that it seriously prejudices an accused to not know what are the contents of the ECIR. Because though the ED says that an ECIR is an internal document, it has no statutory backing, etc. An ECIR is really the initiation or the starting point of a ED investigation, and it is what they record in the ECIR is then investigated. The persons who they suspect are involved in money laundering are also named in the ECIR. So it's really the starting point, and we have always been arguing that it's akin to what is an FIR. The courts in our country over the years have held, both in the context of an FIR and even otherwise under criminal law, as a first principle that an accused has to know what is the allegation against him, and it is important to know that so that he can give an answer, prepare for his defense, invoke his statutory rights like filing for an anticipatory bail, etc. So really, in fact, the right to know what is the accusation has actually been held to be a facet of Article 21, such as it's a fundamental right. And in this vein, we had argued that when you are investigating a person under the PMLA, he has to know what is the allegation. Now, this entire procedure is completely opaque, right from the recording of the ECIR to a point where a person is summoned. A copy of the ECIR is not given, the allegation is not there in the summon, and everything under the sun from a person's financial statements, his financial record, his family's financial records are sought by the ED. So really, not providing an ECR is like it's completely opaque. When you go and face the ED, you don't even know what is the allegation. So it then gives the handle or the leeway to an ED officer to misuse his powers, and we can ask it. It actually then becomes a fishing and roving inquiry against you without even you knowing what is the allegation. That's the problem.
Right, sir. So what we've seen in cases where the quashing of an FIR is being sought, there are multiple cases which are filed daily. So, sir, is it possible for the accused to approach the court seeking, say, a quashing of the ECIR, especially given the fact that ECIR might not even be available with the accused at the time?
So I would say the right is still available because it's a part of the inherent powers of a High Court under 482. So a person who's facing an ED investigation can always approach the High Court, but he'll be handicapped without the ECIR. And now when you go to the High Court, earlier we used to ask for quashing of the ECIR. Now the prayer may be tweaked to ask for quashing of all investigation under the PMLA. So the remedy is still available, but I think it's become more difficult because when you will approach, say, the High Court for quashing under 482, the High Court will also ask what is the allegation, and without you knowing what is the allegation, it's very difficult even to comprehensively raise grounds for the challenge. So yes, it has become difficult, though the remedy is still available.
Sir, so under PMLA, the offense of money laundering, as you rightly said, is premised on the existence of the scheduled offense. And without the scheduled offense, there cannot be an offense under PMLA. And the judgment also says that if there's a discharge or acquittal in the scheduled offense trial, or say a quashing of the scheduled offense FIR, the PMLA case against the accused cannot continue. So could you please elaborate on these processes of discharge, acquittal, and quashing, and how difficult or how time consuming each of these would be?
So again, to just tell you that again, it had been a consistent argument across all forums. that deholds or without the schedule offense, there can't be PMLA. And it was a very logical argument which was emanating from the statute itself. And we didn't need judgments for it because the way the proceeds of crime are defined, the proceeds of crime are something which arises from the schedule offense. So you need a schedule offense. And it is those proceeds of crime which are then laundered and then becomes the offense of money laundering. So our consistent argument was that if there is no schedule offense, there is no proceeds of crime, and there is no question of commission of the offense of money laundering. Now, that's the silver lining in this judgment and this argument, though the high courts across the country have taken different views. The ED contrarily argued that no, we are a standalone offense and we just need jurisdiction. We just need the commission of the schedule offense as to start our investigation. Then what happens thereafter with the schedule offense is not our concern. Once we get that jurisdiction and start, we don't really care about what happens in the schedule offense. The Supreme Court has struck down their argument and has very clearly held now that the proceeds of crime is the core of the offense. And without proceeds of crime, without a schedule offense, there is no question of continuation or commencement of a money laundering case, though there are a few exceptions to that in the judgment. So I think it has now become imperative that to see what happens in the schedule offense.
So, sir, how long do these processes of, say, discharge, acquittal, and quashing would generally take, and how easy or difficult is it to get any of these remedies? And how would a defense lawyer decide which of these course of actions to take?
See, it depends on case to case, and really on the facts of a case, on whether you go for a quashing, or you make out a case for discharge, or you face trial and then get ultimately acquitted. And the standards and parameters are different at every stage. Quashing is the quickest remedy and also the most difficult, because to make out a case of quashing, you have to show that the allegation on the face of it and taken to be true does not make out the offense. And the parameters of quashing have been very well laid down by the Supreme Court, right from the judgment in Madanlal's case. So quashing is something which, depending upon what the allegations are, we advise our clients to do. It is also from various high court. It depends on which high court you are before, and that time span is then determined. As far as discharge is concerned, that's a time-consuming process, because first the FIR is registered or an investigation is started in a special act. Then it goes through the stage of investigation, and then a complaint or a charge sheet is filed, which then the accused is summoned. He goes there. There is a stage of scrutiny of documents, etc. And then you finally reach the stage of charge. So it is a time-consuming process. But really speaking, the stage of discharge is the first stage after a charge sheet is filed, where an accused can then get a finding of innocence. The stage of acquittal is the stage which is right at the end of the trial. Unfortunately, in our country, the time periods are very, very long. The judicial process is very slow as far as trials are concerned. So the trials, the acquittal will take a lot of time. I would say from quashing up to the stage of discharge or the stage of acquittal, it is a time-consuming and long process.
Right, sir. And so another situation could be where, say, a closure report is filed by the investigating officer in the scheduled offense instead of a charge sheet. Sir, do you think a closure report would have the same effect as a discharge, acquittal, or quashing, in as much as the PMLA proceedings are concerned, that the PMLA proceedings cannot continue?
That's an interesting point you make, because the closure report is not something which is dealt with in the judgment. The judgment uses the words quashing, discharged, or acquitted, and also uses the words by or finally absolved by a competent court of jurisdiction. Now, as you would know, what a closure report is something which is filed by the police or the agency which is investigating after it completes its investigation and comes to a conclusion that no offense is made out. Under the CRPC, when a closure report is filed before a magistrate, And again, that procedure has been very well laid down by various judgments of the Supreme Court. The jurisdictional court is not bound to accept the finding of the agency. It can either accept it, it can say, no, I don't accept it, and summon the accused. It can issue a notice to the complainant, who can then file a protest petition. So I would say, as far as closure reports are concerned, to get any relief under the PMLA arising from that case, the competent court would have to accept the closure report and come to a finding that no offense is made out. So I would say that the very filing of a closure report will not give relief or remedy to an accused facing a PMLA investigation. Of course, during the pendency of the procedure before the competent court, whether to accept the closure report or not, you can always argue before a court that till that stage happens, the PMLA investigation should be stayed or stalled of offense. So if they have not found, and subject to what the court holds, why should a PMLA investigation continue?
So, sir, stemming from the relationship between the scheduled offence and the PMLA offence, and from what you said earlier about the trial, the investigation in India taking a lot of time. So, sir, do you think this would be a bigger problem in, given the fact that the investigation or the trial in the scheduled offence might proceed at a very slow pace? For instance, the FIR might be, say, registered in 2015, and the investigating agency might still not have filed a charge sheet till date. So the trial in the scheduled offence cannot commence. But at the same time, ED might have registered the ECIR, arrested the person, filed the complaint, and initiated its trial as well. So wouldn't this cause great prejudice to the accused person, and is there a way out of this?
You're absolutely right, and this is practically the problem which we are facing in a number of cases. That is to say that there is an FIR which is registered, but say by the CBI or the local police. They don't even commence investigation. And the minute the FIR registered, the ED comes in and registers an ECIR. And the ED moves with great pace. So even without any inch of investigation moving in the scheduled offense, in the ED case, you'll have them summoning the accused, arresting the accused, attaching their properties. And it's a big problem. And we have been arguing in various courts. We have had cases where, like I said, there is no investigation in the scheduled offense, and the ED has arrested the person, investigated, filed a complaint, and the persons are languishing in jail for years. And there is no investigation in the scheduled offense. And ultimately, imagine a case where after investigation in the scheduled offense, the agency files a closure report and that is accepted. That's the end of the PMLA case. But by the time that happens, severe damage is done to the reputation and dignity and life of an accused, because he's arrested or his properties are attached, he's financially crippled. So it's a big problem. But as far as this judgment is concerned, the silver lining is that at least they have held now without the scheduled offense, there is no PMLA. So now I think one of the grounds which is available to us to argue across, say, in a bail petition or to file a quashing or even at the stage of discharge, one of the arguments which we can now make is, look, what it's the proceedings have not even commenced in the scheduled offense. And at the very least, you can't keep a person in custody in a case like that.
So is there a way out of this? For instance, I think Section 44 talks about clubbing of the scheduled offense and the ED offense. So how long, how beneficial would that be for an accused to probably club the cases so that, he's not prejudiced unnecessarily because of the delay on part of the investigating agency in the scheduled offense?
Yeah, so this is a very interesting point you make. If you look at 44(1)(c), which is the provision dealing with clubbing of a PMLA trial and the scheduled offense trial, the provision only gives the power to an ED authority, to an accused, to do this. And in fact, we've done, and we are arguing this in a number of cases where the scheduled offense is pending in Court A and the ECIR proceedings are pending in Court B. And as an accused, the authority is not gone for clubbing. As an accused, we have gone to courts and say, you please club the two. Because, and I think it's become more imperative now to do this after the judgment, because then both cases will proceed together Unlike a situation where the PMLA case has commenced with great haste, and you've reached the stage of judgment, and there is no investigation even in the schedule offense case. So now, in fact, we are advising a lot of our clients that as an accused, we must seek clubbing of the two cases so that they both proceed at the very least at the same pace, and the ED case is not moving faster than the schedule offense cases.
So moving on to the provision of bail under PMLA, which is probably the biggest reason why the PMLA is called a draconian statute. So Section 45 of the PMLA provides for the twin conditions for seeking bail under PMLA, and that provision has been upheld by the Honorable Supreme Court. So for the benefit of the audience, the twin conditions are that the public prosecutor shall be given an opportunity to oppose the bail, and that the court must be satisfied that there are reasonable grounds that the accused is not guilty of the offense that he is accused of committing, and that the accused is not likely to commit an offense while on bail. Now, sir, given the extremely stringent conditions, how can an accused person protect themselves from arrest by ED?
Just to put this in perspective, though the Supreme Court has upheld the conditions as constitutionally valid, I would say they have diluted the test a bit to say that the court now does not have to come to a finding of guilt, but the court has to look at a prima facie view as to whether there is a commission or not. And the court has also said that the court which is dealing with the bail application does not have to meticulously look at all the material. This was also the law laid down in a judgment of the Supreme Court in Ranjit Singh Bramsey's case, where it was dealing with a provision under the MOCOCA, which is a similar provision to that of PMLA. So now the test, though the conditions are now applicable and will apply on all cases across the board, the test has been lowered a bit as far as an accused is concerned. But having said that, what happens when you argue these cases practically will have to be seen. But as far as an accused is concerned now, there are a number of arguments which can be made. And I think the crux really is when the court is looking at the material, the crux is what is the documentary material which is available with the ED to show whether a person is guilty or not. Because we've seen in a number of cases, the ED mostly relies upon statements which are recorded of various persons. So I think as a defense counsel now, our primary argument is going to be that you do not only look at the oral evidence, which are the statements recorded under 50. And the reason for that is at the stage of bail, which is actually a preliminary stage during the course of these proceedings. An accused does not have a right to cross-examine the persons whose statements are recorded. So take a situation where ED records statements which are tailored to their case. It then becomes very difficult for a defense counsel to go and argue that please do not look at these statements. So I think the argument which is now available, on which I think we should as defense counsels make, is to say that you do not only look at the statements, but please look at the documentary evidence which supports that statement. And if you don't have the documentary evidence, applying the test which has not been laid down by the Supreme Court, an accused should be granted bail. The other defense which has been made available through this judgment and other judgments of the Supreme Court is that they have said that the right to a fair investigation and trial is now a facet of Article 21. The Supreme Court has held that insofar as constitutional courts are concerned, the High Court and the Supreme Court, when they're dealing with these bail applications, if they feel that there is an infraction of these Part 3 rights, which is to say that there hasn't been a fair investigation, or there is a chance of delay in trials, the court can then not apply these conditions and grant bail to the accused. So I think one of the arguments which is now available at the stage of bail is to say that please look at the material, and the investigation has not been fair in this case, and therefore there is an infraction of 21, and therefore do not apply these conditions and grant bail. So I think these are the defenses which are now, they are limited, but these arguments can still be made.
So, sir, one of the preconditions, according to the statute, was, as I said, that the court should be satisfied that there are reasonable grounds that the person is not guilty. But as you say, sir, it has been diluted by the recent judgment to more of a prima facie case. But sir, given that most of the accused would not even be aware of the contents of the ECR since it has not been given to them, or the allegations, or the exactly what material is there against the person, wouldn't it be some sort of a obstacle while seeking bail, and wouldn't we be in a similar situation to what we were, as we discussed in the case of quashing, where we don't even know what is the evidence, what is the allegation against us?
Yeah, it is. It is a difficult situation. Definitely, there is no doubt about that. And I think more than your anticipatory bail is now it's an illusionary remedy under the PMLA, I would say, because if in fact, there is a constitutional bench judgment of our Supreme Court in Sushila Agarwal's case, which is to say that when you move an anticipatory bail applications, you need to, in your application, deal with the allegations, give an answer to it, and say how your custody is not required. And that's a constitutional bench decision. Now, if you look at the PMLA proceedings, you don't even know what is the allegation. You don't even have the ECIR. So what do you go to the court with? So it becomes very difficult. Now, practically, I think what will happen is you move an anticipatory bail without knowing what is the allegation. And the court will ask the EDU, please file a status report. And then at that stage, maybe the allegations will come out and you give a rebuttal to that. So it's become very difficult. Yeah.
So the proviso of Section 45 makes certain exceptions where the rigors of Section 45 of the PMLA would not apply. It says that a person who's under 16 years of age, or a woman, or is sick or infirm, or if the accused, either on his own or along with other co-accused, the amount of money laundering involved is less than 1 crore, they may be released on bail if the special court so directs. So, how difficult is it to get a bail under the proviso where the Section 45 twin conditions do not apply?
If you look at the wordings and which you just read out, it uses the word may. It says the court may not apply, may grant bail. So, firstly, it is discretionary. The power is with the court whether to grant you relief under the proviso or not. And though it says it uses the word women, sick, infirm, etc., end of the day, it's left to the court's discretion to determine your medical ailment and whether that is fit enough or your age is good enough for you to fall under the proviso. In other words, just because you're a woman, it's not mandatory for the court to not apply the provision on you and grant you bail. So the proviso is there, but I think with the discretion being there, I would say it's equally difficult for even a woman against whom there are allegations, or a old person whom against their allegations, to say that you please do not apply the proviso to me. Of course, if you are sick or infirm and your medical condition is serious, those things are taken by the court into consideration.
So the general trend is that even the special courts are not very open with exercising the jurisdiction and their discretion under the proviso.
Yeah, I would put it differently to say that just because you're a woman or you're sick or you're infirm, it's not that it's going to be easy for you to get bail. You'll still have to deal with the allegations.
Sir, in another recent judgment of Satyendra Kumar Antil, a two-judge bench of the Honorable Supreme Court had laid down various guidelines for granting bail. For instance, it held that if a person has not been arrested during the filing of the charge sheet, or in case of an ED complaint, he or she is ought to be granted bail. Or there are other line of judgments which have held that where the trial is going to take significant time, the accused ought to be enlarged on bail. So, how do you think this interacts with the restrictive approach on bail taken by the larger bench of the Honorable Supreme Court in Vijay Madanlal Chaudhary, or the provisions provided for in the statute?
Judgment in Vijay Madanlal, judgment we're dealing with here, it does not deal with the latest view in Antil's case. Though Antil's decision is a judgment by two honorable judges of the Supreme Court, and Vijay Madanlal is three honorable judges. Antil's decision came much later. It came closer to when this judgment had come. So obviously the arguments were over by then. So this aspect of what Antil has laid, which is to say that in a case where a complaint or a charge sheet is filed without arresting an accused before the court, he or she ought to be granted bail because the agency did not feel the need to arrest the person during investigation. So there is no need that for a court to take that person into custody pending the trial. Now, what the latest judgment of Until did, and there were two other earlier views, but the third judgment dealt with what happens in a case where under the special acts such as the PMLA, etc., where you have these restrictive conditions, and a complaint is filed without arresting an accused. And there, the Until judgment made it very clear that even in those cases, when an accused comes before the court post filing of the complaint and is not arrested during the investigation, the court has to grant bail. So, insofar as Until is concerned, that is definitely a relief to persons who are not arrested during investigation, because otherwise, if this view was not there, you would go to the court when you're summoned, and there again you will have to face these rigors of 45 with the complaint being there and deal with the allegations in merit without even reaching the stage of trial. So the Until judgment is a relief, definitely, and it is being applied by various courts, at least insofar as Delhi is concerned. We know a case where after Madanlal, when the accused appeared before the court, they relied upon Until's case and held that that Madanlal did not deal with Until or the situation in Until and granted relief to those accused. So Until is a relief. Insofar as the other judgments are concerned, and there have been two recent views of the Supreme Court in the context of SFIO cases, two recent judgments by Justice Chandrachud, where they have said that if there is a chance of delay in trial, and again they've linked it to the right to fair trial under 21, the Supreme Court has very clearly said that these conditions will not be an issue and you can grant bail to an accused.
So now moving on to the last topic for today, and this is the hotly contested issue of provisional attachment. So could you please explain a little on what is a provisional attachment order and what is the procedure that is generally followed by ED to attach a property?
So very quickly, the provisions which deal with provisional attachment under the PMLA are essentially Section 5 and Section 8. Section 5 is when do you provisionally attach a property and the circumstances, and what is the validity period of an attachment. And 8 is the adjudication procedure. To put it simply, an attachment is done when an officer apprehends that a property which is involved in money laundering will not be available or will be sold or alienated, and therefore it will not be available for the proceedings under the PMLA starts. So what an officer does is he attaches those proceeds of crime. Now these proceeds of crime are attached for a period of 180 days from the date of the attachment. And once the attachment takes place, the next thing which the officer has to do is within a period of 30 days from the attachment, he has to file what is called a complaint before the adjudicating authority. Now, adjudicating authority is an authority established under Section 6 of the Act and has retired officers, IRS officers or officers who are competent to be district judges. The adjudicating authority is in Delhi, and it's now there is an officer who's there. So the ED files the complaint before the adjudicating authority. The adjudicating authority looks at the complaint, has to formulate its reason to believe to come to a conclusion that whether a show cause notice has to be issued or not. A show cause notice is issued to the person who either owns the property or where the authority feels that X person is involved in money laundering. A show cause notice is issued to that person. Then that person appears before the authority, a right to file a reply is given, and there are arguments which are addressed. And then the authority has to either confirm or set aside the attachment. So this procedure is given under Section 8. And once the provisional attachment is confirmed, under 8.5 of the Act, the ED officer has a right to take possession of the property. Now, this was also one of the major arguments which were being made as defense counsels before the Supreme Court, is to say that if there is a confirmation, ED possesses the property or takes the property away from the person who is either owns it or enjoys that property, it's a very drastic step. merely because it is confirmed, you are now taking the property away from the person. So Supreme Court has agreed with the submission, though it has not said that it is unconstitutional, but it has said that you can only take possession in rarest of rarest cases. And the ED will now have to give reasons why a post confirmation it is taking possession of the property.
Okay, sir, so the judgment also makes a distinction between attachment and confiscation. Could you please elaborate a little on that aspect, sir?
The attachment proceeding starts from the provisional attachment order, validity period of 180 days. Within 30 days, a complaint is filed. Authority decides it. If it sets aside the attachment, that's the end of it. But if it confirms the attachment, then those remain confirmed during the pendency of the trial. Now, after it is confirmed, the fate of the property then gets linked to the trial of the scheduled offence. Now, say a complaint is filed before the special court, and the PMLA trial commences. Now, after the PMLA trial finishes, if a person is convicted, then that attached property, which is confirmed by the authority and possession may or may not be taken by the ED, now gets confiscated to the government. Essentially, the government then confiscates and owns or takes over the property. And if there is an acquittal, then of course the property is released either to the person from whom it was attached, or even a bona fide claimant can come to the special court and say, look, the property belongs to me and therefore it should be released to me. So confiscation, to put it simply, is a stage which happens post the PMLA trial and is dependent upon the outcome of the PMLA trial. And confirmation or possession is a stage which is linked to the adjudication mechanism under the Act.
So in these circumstances, could you elaborate a little on what a person whose property has been either provisionally attached or confirmed do to get it released from attachment?
There are two remedies really for a person whose property is attached. The attachment order can be challenged before a writ court straight away. The grounds of challenge are limited, and the law is again very well settled that when you invoke the writ remedy of the High Court or the Supreme Court, when an alternate statutory remedy is available, the grounds of challenge are very limited. You will have to raise some legal ground to go to the writ, because the writ court is going to say that, look, you have a statutory mechanism, go to the authority, why are you here? So the writ remedy is definitely not available on factual grounds. But to give you an example, say an attachment is made in respect of a scheduled offence where a person is discharged or the proceedings are quashed. So there you can always argue, why should I even go to the authority? This is without jurisdiction. So in a case where an attachment itself is without jurisdiction, you can always go to a writ court. And in the example I just gave, you go to the writ court and say that there is no question of attachment because there is no scheduled offence, and therefore there is no proceeds of crime. So why are you attaching? But in a case where you have factual defences, where you are going on the merits of the attachment, your remedy is only available before the adjudicating authority. And if there is a confirmation, then you have a statutory appeal. The first appeal goes to the tribunal under Section 26 of the Act. And in fact, you also have a second statutory appeal before the High Court, the jurisdictional High Court under Section 42. So these are the two remedies available in the case of attachments.
So, sir, another question is that on one hand, the Honorable Supreme Court has held that no FIR is required for ED to initiate attachment proceedings. And on the other, it says that not all cases would require attachment. Now, given that the threshold has been put so low, how do you think, sir, it is going to play out practically? Like, do you think the number of attachments is going to increase?
I don't think so. Because, like I said, while the Supreme Court has upheld constitutionality of various provisions, and also, like you said, has said in exceptional cases, they can even commence or issue an attachment order without the scheduled offence. But I think what the Supreme Court really has also done, and I think that's the silver lining in the judgment, and something which, as defense counsels, we should definitely explore, is to say that now they have made given two or three very important findings. One, of course, is the finding which we discussed, that without a schedule offense, when there is a discharge, acquittal, or quashing, there is no question of money laundering. What it has also done is also said that the core of the offense of money laundering is proceeds of crime. And there is a one very important finding, which says that it has to be construed strictly. And it is not that every property of an accused who's facing the money laundering investigation becomes proceeds of crime. You now have to really establish that link between the proceeds of crime and the schedule offense. And it is only if the proceeds of crime are derived from the schedule offense, then there is going to be an attachment or a money laundering proceedings. And if there is no derivation or there is no link, then that property cannot be attached. So I think it's become, while you're right when you say that they make, they can now very easily commence it, but it's become harder for the ED to establish, and in every case now they will have to establish the link between the property attached or the proceeds of crime and the schedule offense.
So, sir, given the new law, probably the properties which were purchased by the accused person before the check period would be protected from attachment. Would that be the case, sir?
Yes, we can say that. So, because the schedule offense, to give you an example, say a person acquires a property in, say, 1990 or the year 2000, when even the act was not in force, and the commission of the offense takes place later, say in the 2010 or in 2012. So why it will be an argument for the defense to say that there is no question of that property being derived from the schedule offense, because the years are different. One, the property is purchased or derived in, say, 1990, and the commission of the offense is in 2010. So that argument is available, but the contra to that is, now the Supreme Court also says that you will have to see the date on which the offense is committed. So, say example, you acquire that property in 1990 from proceeds of crime, but you continue to use that property till the year 2010, and then 2010 the offense is added to the schedule. So merely because you are using that property, though acquired in 1990, it becomes proceeds of crime. So these are issues of interpretation. I think these issues will get settled when the courts are dealing with various situations and how they apply this judgment.
That brings us to the end of our podcast today. Thank you so much, sir, for giving us your time. I'm sure this is going to be very helpful and for a number of people to understand the implications and practicalities around the PMLA recent judgment in Vijay Madanlal Chaudhary and the statute itself. Thank you so much, sir.
Thank you, Ash.